What constitute a breach of contract? A contract can usually come before a judge because one or both parties claim that the contract was breached. A breach of contract is a failure without legal excuse to perform any promise that is standard of the injury of the requirements of any express warranty or implied warranty, including the implied warranty of merchantability. When the party claims a breach of contract, the judge must answer the following questions. Did a contract exist? If so, what did the contract require of each of the parties? Was the contract modified at any point? Did the claimed breach of contract occur? If so, was the breach material to the contract? Does the breaching party have a legal defense to enforce of the contract? And what damages were caused by the breach? What are the remedies for breach of contract? There are several remedies for breach of contract, such as award of damages, a specific performance, rescission, and restitution. In court of limited jurisdiction, the main remedy is an award of damages. Why? Because a specific performance and rescission are requireable remedies to do not fall within the jurisdiction of the magistrate courts. They are not covered in the. I'm sorry. What damages can be awarded? There are two general categories of damages that may be awarded if the breach of contract claim is proved. They are um, compensatory damages. Compensatory damages, also called like actual damages, cover the loss of non-breaching party incurred as a result of breach of contract. The amount awarded is intended to make good or replace the loss caused by the breach. There are two kinds of compensatory damages that the non-breaching party may be entitled to recover. Um, First could be the general damages. It covers the loss directly and necessarily incurred by the breach of contract. General damages are most common type of damages award for the breach of contract. And then we have special damages. Special damages, also called like consequential damages, cover any loss incurred by the breach of contract because of special circumstances or conditions that are not ordinarily predictable. These are actual losses caused by the breach, but not that in but not in a direct and or I mean but not in a direct and immediate way. To obtain damages for this type of loss, the non-breaching party must prove that the breaching party knew of the special circumstances of requirements at the time the contract was made. And then we have punitive damages. Punitive damages are also called exemplary damages. Are awarded to punish or make an example of a wrongdoer who has acted willfully, maliciously, or fraudulently. Unlikely compensatory damages that are intended to cover an actual loss. Punitive damage are intended to punish the wrongdoer for egregious behavior and to deter offers from acting in a similar manner. Punitive damages are awarded in addition to compensatory damages. Punitive damages are rarely awarded for breaching of contract. They arise more often in tort cases to punish deliberate or reckless misconduct that results in personal harm. How are compensatory damages calculated? The calculation of compensatory damages depends on the type of contract that was breached and the type of loss that was incurred. Um, some guidelines are like the standard measure. The standard measure of damages is an amount that would allow the non-breaching party to buy a substitute for the benefit that would have been received in the contract has been if the contract has been performed. In cases where the contract of the substitute is speculative, the non-breaching party may recover damages in the amount of the cost incurred in performing that party's obligation under the contract. Contracts for the sale of goods damages are measured by the difference between the contract price and the market price when the seller provides the good or when the buyer learns of breach. What is equitable relief? Equitable relief, it's a court grant remedy that requires a party to act on refrain from performing a particular act in cases where legal remedies are not considered to provide sufficient restitution. How it works? Equitable relief is distinct from a legal claim such as monetary compensation and is employed to prompt or prevent and actions in cases when a legal remedy would not constitute adequate restitution for the breach of contract or other offenses. This prompting often takes the form of a court injunction, which enforces the remedy by punishing non-compliance with civil or criminal penalties. The offended party must also be found to be entirely free from blame in the dispute, often called the clean hands principle. It can be applied to deny equitable relief if the offended party has not acted entirely in good faith or has delayed unnecessarily in seeking a remedy. Damages are other equitable remedies for a breach of contract. Generally, there are two types of damages that can be awarded in breach of contract. Compensatory damages, sometimes called actual damages. I already talked about this. But I want to explain a couple more because we have compensatory damages that are designed to put the non-breaching party in the same place they would have been if the breach have never occurred. We have consequential damages are related to the breach of contract without direct correlation. Nominal damages are damages that are awarded when there was a breach of contract but not real harm result from the breach. And we have liquidated damage awards. The parties contract may provide from liquidated damages. Liquidated damages are the amount the parties have agreed to pay in the event of breach. liquidated, liquid, I don't know how to pronounce that, I'm sorry, damage. Provision are often included in contracts where it would be difficult to quantify the amounts of damage in the event of breach. Limitations on monetary damage awards. A party enforcing a contract cannot recover damages that are speculative. There must be some basis of the damage that a party seeks. Um, Now I want to talk about the mitigation damages and hold on. I want to talk about mitigation damages. The mitigation of damage doctrine, also known as the doctrine of avoidable consequences, prevents an injured party from recovering damages that could have been avoided through reasonable efforts. The duty to mitigate damage is most traditionally employed in the areas of the tort and contract law. In the breach of contract case, upon receiving notice that one party to a contract does not intended to perform, the other party is required to mitigate damages, meaning that it must take responsibility for efforts to avoid future losses from the breach. Um, Mitigation of damages has also been involved in the field of property law. And here are three common non monetary remedies for breach of contract. The first one is a specific performance. Sometimes you just want to get what you paid for, whether it could be like real estate, goods, intellectual property. You just want to get what you paid for. Then we have rescission of the contract. Another equitable remedy is rescission of the contract. That's when a party sues to unwind or unmake the contract. The goal is to return the parties to the state they were in before entering into the contract. In other words, the status quo, as if the contract never existed. And we have reformation. Sometimes the parties to a contract find that there is a discrepancy between the agreed in terms and what they believe the terms to be. In that case, reformations may be a solution. Reformation is where the court allows the wording of the original contract to be changed when the contract verbiage is ambiguous, a mistake has been made, or when one of four parties do not understand the expressed terms. And remedies for breach of contract. It's possible that the party damaged by the breach of contract may choose to ignore the breach, and this is called waiver of breach contract. Waivers are granted in several ways, included through conduct. For example, one party made a late payment to the other, and the late payment was accepted. This would be waiver of breach of contract through conduct. A waiver might be implied or expressed. If you decide to waive a breach of contract, it means that you're giving up your right to pursue remedies for the breach. You should also remember that you will still be responsible for performing your contractual duties and will not be able to use breach as an excuse for non-performance. A waiver of breach of contract only applies to a single matter. The injured party can still require fulfillment of the rest of the obligation described in the contract. When one party is damaged by the breach of contract, they have the right to receive damages. In most cases, the damages will take from of money, which is meant to restore the party's financial position prior to the breach. Thank you.